All right. Good afternoon. This video is the final two chapters, chapters 13 and chapters 14 in the Crim 1 course at Madera Community College. I am the instructor for the course, Mr. Ybarra. As always, I would highly suggest that you print out the PowerPoints for chapters 13 and 14 and use those while we go through this lecture, while you go through it, rather, and I present it. That way you can, note areas that are going to be of importance. You might hear me say you'll see this again, and that's your key to go ahead and note that. And then you could also write in the margins for notes that I discuss during the lecture itself. So these last two slides are going to cover essentially juvenile justice and how that's applied, and the last one is going to cover some of the changes that criminal justice system is undergoing as a result of changes in society as well as changes in technology, and we'll address those as well. All right, so first slide on chapter 13, History of Juvenile Justice. You've heard me use the term once before in a previous lecture called parens patriae, and that's Latin for father of his country. And essentially it's a legal philosophy or legal doctrine that the government maintains the guardian of the child, maintains guardianship of the person, rather, in this case children, who have a disability or are children and have a legal duty to act in their best interest until they reach an age of maturity. So that's how the criminal justice process for juveniles was originally structured. And it still maintains that same idea today. And honestly, those two really aren't compatible, but we are kind of making them work. And we'll get into compatibility issues a little bit later on in the lecture. Poor laws established in 1535 are English statutes that are bound out, which if they bound out something, that means the court has released the juvenile, in this case, to the care of, in this case, masters. So this was English. This is, remember, a lot of our laws and processes were adopted from English common law, and this was one of the mechanisms. So when a child was apprehended, poor laws, those statutes allowed the child to be essentially released to people who would take these children in. You know, they provide room and board and everything else, but at the same time, they essentially used them as slave labor. The delinquent juveniles would be placed into courthouses or workhouses where they would be apprenticed until adulthood. So you're going to see delinquent used a lot. So when they say delinquent, the equivalent of delinquency is criminality. So they're going to basically, when you hear delinquent, that means criminal. So criminal juvenile, delinquent juvenile. And we're going to get into why some of those terms are used specifically with dealing with juvenile justice a little bit later on. Chancery courts provided judicial relief to those who had no legal standing, especially children, as a result of corruption or inadequacy of common law courts. The Chancery Court protected the property rights and welfare of minor children and also dealt with issues of guardianship and the use and control of property. So Chancery Court was the initial juvenile justice system that was in England, and of course they moved those over to the United States. Middle-class civic leaders referred to themselves as child savers here in the U.S. in the early colonies, and developed programs for troubled youths and influenced legislation creating a juvenile justice system, so a very rudimentary system. Early on, the institutions, when a juvenile was convicted, those institutions were considered house of refuge, and they were run like correctional institutions where juveniles were racially and sexually segregated. And then, of course, discipline was pretty harsh, involving whipping, isolation, and of course, physical care was relatively poor. They didn't have a lot of resources back then, obviously. And then, 1853, the Children's Aid Society, was founded, which was a child-sitting organization that took children from the streets in large cities and moved them out into the rural areas in hopes of trying to get them to become more wholesome, as opposed to, basically little street rats that are running around doing whatever. It gave them structure in their lives. So those were a lot of the mechanisms that were implemented early on. But obviously, with not a lot of resources, when you have the colonies forming into the states and the states forming into the nation, children were kind of on the back burner because most of the crimes that they committed were nuisance crimes, right? They were just, most of them were public order crimes, so that was the primary issue there. All right, slide number 2, juvenile court. The first juvenile courts here in the United States were established in 1899 by the Illinois Juvenile Court Act. So you're going to probably see that again, 1899, first ones by the Illinois Juvenile Court Act, which set up an independent court to address juvenile delinquency and to care for neglected and wayward youths. So the courts, and unlike criminal courts for adults, the juvenile courts work off of 2 principles, right? So they adjudicate criminal activity by juveniles, but they also act as parents patriae and take care, control, and custody, or defer them. They monitor these kids for ones who have been neglected and are put into a system through no fault of their own. So, for instance, if you had parents who were involved in the drug trade together, the whole family was, and they didn't have any resources, then the kids would wind up becoming wards of the state under the juvenile court's control, and then, of course, be placed into foster families and that kind of stuff. So juvenile courts take a much more rounded role when it comes to dealing with juveniles, because they deal with them as a whole and not just necessarily criminal behavior by those juveniles, which of course they deal with, but those courts have other duties. And so that's what they're talking about with the parents patriae, right? The courts can't just look at kids in a punitive way. So they have to look at them in a nurturing way. And when you take what a court's responsibility is, which is fact-finding and punishment, sanctions, and you try to incorporate something that's completely opposite, which is nurturing and care and direction, then sometimes those things don't really mesh very well. And we'll see that, although we will also see that even though there are flaws within the system, they've made them work together like you wouldn't think they would work together. Kind of like when you try something that you're like, wow, this, for instance, I've never had one, but my kids did, and they swear it's the best thing ever, was a peanut butter and jelly hamburger. I think they have one at Lazy Dog. And they bought it, and they ordered it, and I was like, oh, fine, whatever. Go ahead if that's what you want to give it a whirl. Like, that doesn't sound very appealing, but okay. And they swear it was the best thing ever. And so, by virtue of that, they managed with the addition of other ingredients to make something unique as well as palatable, and kind of the same thing that's happened with the juvenile court system. All right. So delinquency, like I said, is the engaging of criminal behavior by a juvenile. So again, if you see juvenile delinquent, that means it's a juvenile criminal. Juvenile courts became established in the United States. They provided juvenile justice with quasi-legal and quasi-therapeutic justice. Remember, we talked about the idea of trying to help the children, but at the same time trying to keep them, from engaging in crime, keep the community safe. So, and it was based on the best interest of the child, not always on the best interest of the community. So, like I said, that's where you have that bump, that rub. There was no strict adherence to case law, constitutional rights, or due process. Attorney representation was not required. Hearsay evidence was admitted, and juveniles were often encouraged to admit guilt in court. If the case went to trial, findings were based off of preponderance as opposed to a higher standard, which is reasonable doubt. And the court took a paternalistic, which means a fatherly role, rather than an adversarial approach in dealing with juvenile delinquency. So there's a lot of information, and we'll kind of break that down. So what it basically means is that as opposed to looking at all the rights and privileges that a person has going through, an adult has going through a criminal process, the courts assumed a fatherly position when dealing with children. And so by show of hands, again, the show of hands thing, I'm sure most of you, when your parents are punishing you when you were children, or if you have children now and you're punishing your children, it's not because you take any joy in the punishment. It's because, one, you're trying to hold them accountable for the misbehavior in hopes that the punishment will be severe enough that they will consider re-offending, doing that same thing that got them in trouble in the first place again. So that's number one. And number two, you're trying to teach them that it's not okay to do certain things, right? We all have standards that we all have to live by. And that's exactly what the court is trying to do. So like in the instance we shared here, that the courts often try to encourage the children to admit guilt. Well, we do that all the time. If you lie to me, it's going to be worse, right? Could you ever see that happening in criminal court, right? Could you ever see a judge admonishing somebody or the prosecution admonishing somebody that is on the witness stand? If you lie, you're going to get in trouble, that kind of thing. It doesn't happen, right? So with juveniles, they did that, and they did it because that is kind of the part and parcel of being a parent. As parents, we're fact finders, and we utilize numerous strategies to find the truth. In the court of law, those strategies probably would not, be welcome. So that's the rub. So a lot of people think that's not fair, right? And they're like, oh, well, that's wrong. You're making the kids admit guilt. What if they really weren't guilty and they just want to get... And that does happen. We have those kind of problems. But on the flip side, there are so many avenues that the courts are given, especially juvenile justice courts, with regard to diversion and everything else. I've seen instances where kids have gotten into trouble, like vandalism or something, that they went and did something dumb, right? And it wasn't fatal. It wasn't, it was just they went and painted a wall or something. And the judge said, you're going to go and you're going to clean all the paint off and you're going to repaint all that wall. And then you're going to come back and demonstrate to me that you did it. You can get a letter from the owner of that wall, and once they do that, then your sentence is fulfilled, right? Your penance is paid. That probably would never happen in adult court, but in juvenile court, it gives them a lot of latitude to be able to do that, so that way the kids aren't saddled with being a criminal as they move into adulthood. All right, so early juvenile justice, if juvenile courts found the offender guilty, they were placed in reform schools, which were non-punitive schools that exercised control through the concept of hard work and discipline. Later, in the later half of the 20th century, reform schools gave way to the cottage system. You're going to see this, reform and cottage. So the cottage system, where juvenile offenders were housed in a series of small cabins, and most of them were rurally located, in an attempt to create a home-like atmosphere and again move them out of the big city and into smaller communities where there was easier accountability. There wasn't, they could put them to work, and they start to grow a sense of responsibility. And by the 1950s, psychological treatment was introduced, so was group counseling, and that became a standard process in juvenile institutions because we realize that while kids are resilient, right? You've seen how many times have you seen a kid booking down the street and all of a sudden munch it hard, and then they get up and they got a scraped knee and they brush themselves off and you go. And then if you were to do that, go booking down the street, or especially me, as old as I am, go do that, and I fall and I have a scratch on my knee and maybe a ripped pair of jeans, I think my recovery is probably going to be 3, 4, 5 times that of that kid. Kids are resilient, not just physically but emotionally. They can move back and forth. But that isn't to say that children don't recall these things, and these events don't shape their thought processes when they move on. So part of that is that intervention that we're going to give them, saying, hey, look, we know you went through this. It was very troubling. This is the way to handle it, right? And so we're trying to give them the tools necessary to be able to deal with those emotional issues that they're going to have. And the counseling, the psychological treatment was found that it was really necessary for some of these kids. Okay, juvenile justice has shifted philosophies from inception, where juveniles were treated similarly to adults, through the late 19th and mid-20th century, to the concept of parens patriae, and that was like right around the 80s, 1980s, through the 60s, through the 80s, where constitutional due process was introduced into the juvenile justice system. And then now, the juvenile justice system is focused on juvenile crime control and punishment philosophy coupled with treatment for needy youths. So we've moved, our pendulum has moved. It continues to, depending on, remember we talked about an evolution of society, right, with with the introduction of new technologies and moral changes within the community, then you have to understand that that's going to filter down to the kids as well, right? So when these kids start getting this new information, they start behaving differently. Our criminal justice system has to be able to adapt as well. All right, moving on to slide 3, juvenile justice today. Juvenile justice is the participation in illegal behavior, or juvenile delinquency rather, sorry, is a participation in illegal behavior by a minor who falls under a statutory age limit. So what is the statutory age limit? Well, in effect in the United States it's 18, right? In some cases, for certain things, it's 21. That's for drinking and that kind of stuff. But for 18, the United States recognizes, and there are some cases that allow for a lesser age, and those are specialty cases, emancipation, like if a child gets emancipated. But for the most part, 18. So, and you're going to see this one again here. A status offender is a juvenile who engages in behavior forbidden to minors but not illegal for adults, such as truancy, violating curfew, running away from home, and consuming alcohol. So we spoke to that earlier. Most of the time, kids get into trouble for status offenses, right? That they leave school without permission, so or they don't go. Yeah, Mom, I had a great day at school, and they haven't been there for 3 weeks. Truancy, violating a curfew, right? Some areas in California have curfews for children, and they can't be out after X o'clock in the evening without a parent or guardian present. Running away from home, obviously, and consuming alcohol. So all these things as adults are not criminal. I mean, even running away from home. Sometimes you probably feel like you want to do that. You're like, I don't want to do this anymore. I'm done adulting and I need to leave. As much as it probably isn't a good idea to do it, it is not illegal for you to do. So for children, it is, and it's called a status offense. And you will see that again. Some similarities between juveniles and adult justice systems include discretion by police officers. Although officers always have discretion, we discussed that earlier in our lectures. However, they tend to have more discretion and latitude that's actually granted to them in dealing with juveniles because of the fact that juveniles don't have a lot of wisdom, right? How do we get wisdom? We get wisdom through life experience. You go, you touch you see the fire, oh, it looks pretty. You put your hand on there, you realize it's hot, it burns. You're like, oh my gosh. That life experience granted that child wisdom, at least we hope, granted them wisdom to know that while fire looks pretty, you probably want to keep your hand out of it, okay? Where were we at here? Truancy. So some of the similarities between juvenile and justice systems include discretion by police officers, judges, and correctional staff, rights to the Miranda warning, procedural safeguards when making an admission of guilt, the right to counsel, plea negotiations, right to hearing and appeal, and the standard of proof beyond a reasonable doubt. So they do get some of these, but they don't get all of them. And so people wonder why. Why wouldn't you give all of them? I mean, if you're giving these protections to adults, you would think you would give all the protections to children too. Well, I'll give you an example of one that we do not give to children, is the right to a trial, a right to a public trial. Well, why do you think we wouldn't give that to a child? Well, because the idea is to try to shelter the child in the criminal justice system from the label of criminality before they've even reached the age of 18, before they're even considered adults. So if they can do that, if we can deal with the criminality and change the behavior early, then we don't want to saddle that kid with the idea that they're a convict, right? I mean, even the verbiage, which we will get into here shortly, changes, but we're dealing with the exact same thing that we would be dealing with in a criminal court. And why does it change? Well, one of the main reasons it changed is because, again, we don't want to have a juvenile convict. A juvenile delinquent, it means the same thing, but it's a little bit softer on the ears, right? And people are willing to look at it a little bit more favorably than if we said that's a juvenile convict. Convict sounds like, okay, this guy's been in trouble. A juvenile delinquent means, okay, this kid has just been naughty. All right, it's saying the exact same thing, just saying it a little bit different to try to not saddle that kid with a label that he or she is going to have to live with for the rest of their life. So that's one of the issues that we're dealing with, again, with parens patriae versus the criminal justice system as a whole. There are a lot of protections that are built in, and some of them can apply to the juvenile justice, but some of them really can't. And they can't just by virtue of the overall goal of rehabilitation first, protection and rehabilitation first, and punishment and accountability next. All right. So some of the differences between juvenile and adult systems include primary purpose of juvenile process is protection and treatment. We just said that, unlike the adult process, which is punishment. Juveniles can be apprehended for acts that would not be criminal if committed by an adult. So a kid that is truant, the cop sees that he's got a bulletin, a bolo for this kid who hasn't been to school in 3 weeks. They've got information that he's hanging around the mall. Cop notices him. He can scoop him up, and away he goes, right? Back to school or back to parents or whatever. Court cannot release personal information about a juvenile to the press, and that's another protection, right? Because we have, as adults, we have a right to a public trial and to press, and so that way we can essentially, the state, it requires the state to be above board when it comes to due process through the criminal adjudication, the whole criminal adjudication process. And then parents are involved in the juvenile process. They're generally not involved as adults unless they are witnesses to the crime or they're there as character witnesses during the sentencing portion. And then juveniles have no constitutional right to a jury by trial, and we talked about why that is. So there are some systems that are in place that, again, easily moved over for children, but there's some of them that did not. Okay. Like adults, juveniles engage in delinquent behavior, and law enforcement has discretion to release, detain, or refer to the court. So considerations by law enforcement include the type and seriousness of the crime, similar to what adults do, the ability of the parents to be of assistance in disciplining or correcting the juvenile, and that is paramount. So, when in that instance we were talking about truancy. So the officer would likely wind up saying, "Where do you live? And who do you have your mom and dad? What's their telephone number?" And as opposed to going right to booking to the jail, they might call mom and dad first and go, "Hey, I found your son, daughter. We have a bolo. Looks like they haven't been reported." And the parents are like, "Oh my God, thank you so much. We've been, I've been driving him or her to school. I don't let him take the bus anymore, and they must have walked away from school." That kind of thing. Well, the cop will go, "Okay, it looks like the parents are legitimately trying to solve a problem." When they're like, "Well, yeah, whatever. We don't worry about where he's at as long as I know he's not dead, so that's cool." Then if they know that the parents aren't going to be actively involved in maintaining discipline or correcting the child, then they may move past that. So they're looking for the degree of cooperation by the juvenile and the parent, and whether or not the juvenile denies the allegation or insists on a court hearing. So there's a number of different things that the law enforcement looks at when dealing with. Again, the main one is the seriousness of the offense. So, if the child is involved in has a criminal charge that is similarly situated to what would be a serious or violent felony for adults, then the likelihood is they're not really going to care what mom and dad want at that point. They may involve them and let them know what's going on, but beyond that, that's probably going to get forwarded to the district attorney for prosecution. After police processing, the juvenile is remanded to juvenile court, the intake division, where the court and probation personnel screen the child and family to complete a report so the prosecutor can determine whether to handle the case informally or bind it over for trial. So essentially, like I said, in the same cases, prosecutors have discretion. And of course, they try to give more discretion to juveniles, especially if there are status offenses or public order crimes or there appears to be parents who are genuinely interested in trying to control the child, but just aren't able to do so because the child is just ain't having that. The prosecutor then makes a decision to release the child to the parent or detain the child pending a trial. The detention is temporary. Is a temporary care of the child alleged to be a delinquent or a status offender who requires secure custody pending a court disposition. And there's been an effort in reforming juvenile detention because some areas utilize adult institutions to house juveniles and placing status offenders in with juvenile delinquents. And so what they're saying there is there are instances where juveniles are put in with adults, and I'm sure that does happen. I just don't think it's happening as much as the book infers. At least in California, I've never seen that happen. Even small communities slash counties such as Madera County, we don't do that here. That's just not done. And what they're talking about with regard to status offenders and juvenile delinquents, a status offender or a person who's a ward of the court as a result of no fault of their own, we talked about that, or someone who just ran away, they don't want to move them in with juvenile delinquents, and these are the ones who have committed legitimate criminal activity, may be involved in gangs and that kind of stuff. So they try to separate those as well. I mean, how fair would it be to have a child who lost a mom and dad in an automobile accident and then move them into a facility that houses, into the same housing facility that houses juvenile delinquents that are undergoing criminal charges? That's just not a wholesome environment, and it wouldn't be fair for the child. Okay, so number 5. Waiver of jurisdiction and diversion. So you're going to see these again. You need to pay really close attention. So waiver is a practice in which a juvenile court waives its jurisdiction over a juvenile and then transfers that to an adult court for trial. And obviously, if a case is going to get waived over, it's pretty serious. In some states, a waiver is also called a transfer hearing, and it's used to determine jurisdiction, while other states may automatically be waived based on statute. So in other words, they're waived automatically as a result of statute, and typically for very serious crimes. So the hearings look at criteria such as age of the juvenile, the prior offense history, and the nature of offense. Essentially the same thing we do in adult court, but in criminal court they're looking at it, or a juvenile court rather, they're looking at it to see whether or not they're going to use a waiver to move them from a juvenile court to adult court. So there's 4 types of waivers that are typically used by the courts for the transference. And both of them, believe it or not, there's transference both ways. Okay? So the first way is a direct file waiver, and that's where the prosecutor maintains autonomy there. So the prosecutor maintains the discretion for filing the charges for certain legislatively designated offenses, either in juvenile or criminal court. So, in other words, the prosecutor really doesn't have much of a choice. This is the charge. I have to bind this over. It's got to go. Excluded offense waiver is where the state excludes from juvenile court the jurisdiction for certain offenses that are very minor or very serious. And what they mean by that is, I'll give you an example. Say, for instance, a child who's 16 years old or 15 and a half gets his learner's permit. And he decides, or she decides, I don't need mom and dad. They're asleep. I don't want to wake them up. I want to go to my friend's house. They ain't going to mind me using the car. So they dump in the car, they go, and then, of course, whoop, they got lit up. That would typically, because it is a criminal offense, would be heard by a juvenile court. But because there is a specialty court that can deal with that offense, traffic, that would also be an excluded offense waiver. So the state law itself says that, no, we're not sending out to juvenile court. We have a court system already equipped to deal with that, and age doesn't bear any, is not going to have any outcome with regard to that. And if it does, that case or those circumstances can be addressed by that court as well. All right, next one. Third one, judicial waiver, which occurs after the informal hearing, and that's like the prelim, okay? So the preliminary hearing would be like the informal, or arraignment would be like the informal hearing, and that's where both the prosecutor and defense, along with the judge, decide to waive jurisdiction and transfer the case to criminal court. So when you hear informal hearing, they're talking about prelim/arraignment. So those are kind of equal together. And then the last one is called a reverse waiver. So in a reverse waiver, they may have state law that mandates that certain cases be tried in adult court. Remember, we talked about statute. Now, after the case is heard, right? After the case is heard, and there is generally they would not refer back for a not guilty finding or well, not guilty. So they wouldn't refer back for non-guilty. So that if it was adjudicated and there was good cause found for that charge, then the adult court may have the authority to send it back to the juvenile court for the sentencing portion, because the juvenile court may have additional options, and we'll know what other sentencing options are available that may better fit. So that's one of the reasons. So after the case is heard in adult court, judge may decide that the juvenile would be better served by the juvenile court, specifically with sentencing, and order a reverse waiver. So remember, 4 waivers. You have direct file, you have excluded offense, you have judicial, and then of course you have reverse. So those 4 are the ones that you need to be cognizant of when it comes to waivers of jurisdiction and then diversion. All right, so slide 6, adjudication. There are 3 judicial hearings in a juvenile court process, and again, they mimic the adult one. First is the initial appearance, and we talked about that a second ago, and that's where the court attorneys are appointed, charges are reviewed, and an effort is made to settle the case without a trial, and it's very similar to the arraignment process in adult court. Second is the adjudicatory hearing, which is also the fact-finding stage, and this is where the court hears all the allegations on the delinquency or on the crime, and as a result of In re Galt decision by the Supreme Court, the concept of fundamental fairness was found to be applicable in juvenile delinquency proceedings, and thus the courts were bound to grant rights that adults have in adult court to juvenile court, such as notice of hearings, right to counsel, right to cross-examine and confront witnesses, and to bring those witnesses forward through the power of the court, the subpoena power, privilege against self-incrimination, and the right to a transcript of the trial record. And then, of course, appeal rights, which were noted. Third stage is called the disposition stage, which is also the equivalent of sentencing for adult offenders. The judge has a broad range, specifically juvenile court, has a broad range of discretion regarding disposition, from dismissal to institutional commitment, which is the juvenile being placed into a correctional facility. Juvenile court also can order a treatment plan when they're incarcerated, or if they decided to use some other alternative sanction, which is a rehabilitative method to use to affect change of behavior in a juvenile offender through the use of therapy, education, and vocational programs. So the courts have a lot of latitude. Juvenile courts specifically have a lot of latitude when it comes to the adjudication process or disposition stage of the process, the juvenile court process. All right. So number 7, juvenile corrections and issues with juvenile justice. Approximately 350,000 juveniles are currently on some type of formal probation. Juvenile probation is most widely used method of community treatment than juvenile court. Given the fact that we don't have a lot of institutions, and the state of California specifically has been closing quite a few of them and scaling them down, moving them back to counties, obviously more of them are going to be placed on probation. It's similar in design and function to adult probation. However, juvenile probation is more intensive in that they have probation officers in areas where juveniles would often be for a significant period of time, right? And where would that be? Well, it'd be in schools. So they're located in schools where their client base spends the majority of their waking hours. Approximately 100,000 juveniles are currently institutionalized throughout the United States, so significantly less than adults, obviously. And that means that they really, really try to focus on ones that have engaged in serious criminality and or continued criminality that's escalating in seriousness. A typical resident of a juvenile facility is about 15 to 16 years of age. White males who have lengthy sentences, 5 to 6 months. Sentences for juveniles don't usually exceed the age of 21. However, in cases of serious or violent crimes, the juveniles are transferred to adult facilities at the 21st birthday or thereabouts, or released to adult parole supervision, and that has happened. I've actually had a juvenile who was released just before, because they adjudicated they completed their incarceration part, and then their birthday was going to be in 2 months, so they want to move them to juvenile parole. So what they did is they moved them to adult parole, and they were on my caseload. And then a couple months later, she had her 18th birthday. It was a female. She had her 18th birthday. Never had any issue with her, only because she was absolutely afraid, because I explained to her that if/when you violate your conditions, and at that time we were revoked into state prison, if your parole is revoked, you're going to be remanded back to state prison. That would be CCWF and or VSPW, as opposed to the county taking you. So she was like, "Oh no, I don't want to deal with that," and that was enough of an incentive for her to abide by her conditions. Some researchers believe that housing juveniles in correctional institutions that mimic adult prisons produce more sophisticated criminals. I disagree with that. There are going to be situations, obviously, criminals, juvenile or adult, are going to talk with each other. I don't know that it produces more sophisticated ones. I think if there's a propensity for that already, and given the fact that we, tend to use in our juvenile justice system a number of different diversion tactics, lesser sanctions, alternative community sanctions, probation. Those are our primary mechanisms for corrective action, and of course involving the parents and the community to try to deal with them. I don't think that that position really holds a lot of water. Are they not nice? Well, absolutely, but you have to look at the clientele there. There appears to be very little consensus between researchers regarding juvenile justice court systems. Some of them say they suggest a return back to the parents patriae philosophy, focusing on rehabilitation and therapy, versus others saying we need to have a tough approach on crime, because juveniles are getting much more sophisticated given technology advancements and the moral fabric kind of changing in our society. Some of the programs, other researchers believe that taking the preventative approach and investing in community programs that intervene positively in the lives of juveniles who are at risk for juvenile behavior, and that would be like the YMCA, YWCA, Boys and Girls Club, and a number of other ones. I will say I absolutely agree with the front-loading idea, not necessarily when they get into the criminal justice cycle, but before it. So in areas that are disadvantaged, where there's a high concentration of juveniles, there absolutely is, and there should be some investment there, not just by the state and the community as a whole, but by parents, and those two coupled together will generally yield a better adult once the kids reach age. So, all right, that's all for this chapter. Chapter 13 is done. If you want to, go ahead and take yourself a quick break while I open up chapter 14, my Canada Dry Ginger Ale. And let's see. Okay, chapter 14, terrorism. So remember I said chapter 14 was going to have different types of criminal behavior and how each of these types are dealt with. They're not atypical street crime. These are all, they're not crimes. Obviously they are crimes, but there's different mechanisms. So we're going to discuss some of these, and then we're going to discuss policing in its evolution as well. So first slide, terrorism. According to the United States, the U.S. State Department, terrorism is a premeditated, politically motivated violence perpetrated by subnational groups or clandestine, so clandestine means secret, they're hidden, agents against non-combatant targets, usually intended to influence an audience. So terrorism essentially is a an act that violent act that that targets non-combatant groups. So if there was you were out in the military and there was a bomb, it would not be considered, according to the definition of terrorism, wouldn't be a terrorist attack. It would be attack, but it wouldn't be a terrorist attack. So the Boston bomber terrorist attack, the bombing of the IRS building terrorist attack, and obviously 9/11 terrorist attack. Domestic terrorism is terrorism involving citizens engaging in terrorist acts within their own country. So, and then international terrorism is terrorism involving citizens or territories of more than one country. So, if we were to look at domestic, when the attack on the IRS building, that would be considered domestic, and international would be the attack on the Twin Towers on 9/11. So, those are very generalized terrorism definitions and specific to the United States State Department. Some of the common types of terrorist groups include revolutionary terrorists, whose goal is to replace existing governments with a regime that holds either religious or political views similar to their own. And then political terrorists are groups of people. Well, with regard to the revolutionary terrorists, we see a lot of that with regard to Middle Eastern terrorist groups. So the Jihad, ISIS, and all of those. Political terrorist groups are groups with a political ideology that target other political groups that maintain an opposing political ideology. And the difference, again, you can kind of see revolutionary can mean that what they're trying to do is replace, and it could be for religious and or political. And then political terrorists is not, their goal may not be to replace, although that does happen. It may be to damage that political party. Nationalist terrorism promotes the interests of a minority ethnic or religious groups that believe it's been persecuted under majority rule and wants to carve out an independent homeland. You can see that with the political the terrorist groups in Ireland. So the NRA, or not NRA, the IRA. The Irish Republican Army, I believe it is, Irish Republican Army. They are the would fall under the nationalist, and there's quite a bit of conflict in Ireland. I don't know how much there is now, but between Protestant Christians and Catholics. So that would fall under nationalist terrorism. Retributive terrorism uses violence as a method of influence, persuasion, or intimidation to get people to accept social, religious, or political views. You'll see retributive terrorism a lot domestically in case from groups like Greenpeace or any of the environmental groups. That would fall under retributive. State-sponsored terrorism involves the use of force by repressive government regimes that force its citizens into obedience, oppress minorities, and stifles political dissent. It kind of feels like what we are now in the United States under our current administration, but I digress. The state-sponsored terrorism is like Iran or the mullahs involving themselves in these types of terrorist acts. And then cult terrorism, sometimes called terror groups, are groups of people who engage in terrorist acts under the direction of a charismatic leader, usually based on fringe religious ideology. And Jim Jones, that's a really good example. And then criminal terrorism is terrorist groups that engage in organized crimes such as drug dealing, kidnapping to fund other terrorist operations, and that would be like the drug cartels, trying to scare each other by hanging each other and killing each other and that kind of stuff. So there's a number of different terrorist categories that are currently scene. You might want to make yourself aware of these. All right. Fighting terrorism. So as a result of the terrorist attack that occurred on September 11, 2001, which caused the destruction of the Twin Towers in New York and the death of about 3,000 U.S. citizens, federal government established the Department of Homeland Security. Before that, it did not exist. And the DHS was the umbrella that other departments now fell under. So they were coordinating the nation's anti-terrorist activities. And some of those law enforcement departments and agencies that fall under the DHS include the United States Citizen and Immigration Services, which was USINS. It's called something different now. The U.S. Border Customs and Border Protection, the Federal Emergency Management Agency, U.S. Immigration and Customs Enforcement, ICE, Transportation Security Administration, United States Coast Guard, and the United States Secret Service all fall under DHS. So with the establishment of DHS, federal government also established the United States Patriot Act, and that was passed by Congress on October 26, 2001. You'll see that again. And it was also, because it had an expiration, it was reaffirmed, I want to say during the Obama administration. The aim was to give domestic law enforcement and intelligence agencies enhanced tools for surveillance, which include easier access for wiretaps, search warrants, pen and trap orders. And a pen and trap order is a device that's installed into telephones that actually records the information that goes between them. And then, of course, subpoenas. So search warrants and subpoenas were the big thing here. I'm sure you guys have heard FISA court. And the FISA court warrants didn't have the same standard of evidence that a standard warrant did. So they just had to have, just enough, and boom, they can get the warrant done and get out. And so a lot of people, there's been arguments on both sides as to whether that was necessary, because all these tools were already available. I mean, our steps for law enforcement to use them were a little bit more. They required more evidence and thus more time. So the argument there is, that could be time that could have been used for the surveillance to verify that, to maybe stop to be preventive, proactive policing. And so that's a valid argument, right? But at the same time, you can also see how easy it would be opening the door for the state to be able to start abusing the latitude that's been given as a result of the Patriot Act. And then, of course, you're talking about not conducting intelligence on terrorist activities, but intelligence on United States citizens without, probable cause. So it's a really tight rope that the government walks on with regard to this. And like I said, the arguments can go both ways. All right, corporate enterprise crime. So corporate enterprise crime, more often referred to as white-collar crime, is the illegal activities of people and organizations whose knowledge and purpose is to profit through the illegitimate business enterprise. And because businesses were primarily interested in recovering the losses, businesses went through civil courts in an effort to expedite the recovery process. And because civil court standard of evidence is less, and we talked about that, many of these businesses were able to recover some, if not all, of their money. And as a result, many early instances of corporate crime were not criminally prosecuted. We talked about that. For large-scale amounts, they were, but on smaller scales, not so much, because it was just easier to accept the loss, otherwise known in the corporate world as shrinkage, right? And even small businesses deal with shrinkage. That's the idea that the employees or people within the agency or have access to the assets of that agency or that department or that, not agency, but that business. They have access to those assets and they take them. And so that shrinkage, it's an unfortunate fact, but many businesses now calculate that into their profit loss. What's the word I want to use? Profit loss calculations to see whether or not, to establish whether or not they're going to raise or lower the prices on their goods or services. Corporate crime also includes fraud and misconduct on Wall Street. Many of these instances of fraud were called Ponzi schemes, so you may see that again. So a Ponzi scheme is investment fraud that involves the payment for payment of purported returns to existing investors from funds contributed by new investors. So basically, there's not really an actual good or service that's being provided. So what they're saying is, if you go and get me 20 people to invest $10, then I get that money, but you'll get a percentage of it. And then their responsibility is to go find somebody who will invest $10, and then they get a portion of that, and you'll get a portion of that, and then I'll get a portion of that. And so it's always a fall. And unfortunately, the very bottom or top, depending on how you work it, because if you're starting here, it would go like this. The very top has invested, and then they don't really get anything unless they can, convince somebody else. So again, Ponzi schemes were designed as inverted money flow systems. They took it from legitimate business, right? The idea was actually taken from legitimate business. I don't know if you guys remember Amway or ever heard of Amway. But Amway works off of that same principle. They actually do have a product, so it's different, but it works off the same type of principle. All right, Securities and Exchange Commission has a responsibility of overseeing the nation's capital markets. They've been tasked with protecting investors, facilitating capital formation, and maintaining fair, orderly, and efficient markets. The SEC finds that criminal activity has taken place. The evidence is set to either the Department of Justice or the FBI for investigation and prosecution. It also, depending on what it is, may be sent to come on, Myron, U.S. Secret Service. So there's a possibility it could go to U.S. Secret Service as well. All right, green crime. This is, I don't want to say new, but it's something that really wasn't taken into account until recently. So green crime is criminal activity that involves violation of rules and laws designed to protect people and the environment. Some examples include illegal dumping, polluting, fishing without a license, poaching, which is a harvesting of wild game without a permit or license. A lot of people would argue that government really doesn't have any right to require licensing for fishing or harvesting of wild game, poaching. There's arguments on both sides. I agree with both. I would not want to have to rule on that decision. For the most part, I will say that all the hunters, I'm not a hunter, but hunters that I know are very environmentally conscious. So they understand that their hunters and fishermen understand that over hunting or overfishing certain spots yields to an overall depletion of that resource, and eventually they're not going to have any. So many of them, take the culling approach, which means only taking a few to allow a natural replenishing of that natural resource. And if everyone does that, then it becomes legitimate, and there's an equilibrium that's established. That's the problem is doing that, and so that's one of the reasons why I believe the law got involved and said, okay, if people can't do it on your own, then we're going to have to do it for you. So again, like I said, there's some government intervention in that, and I see where sometimes government intervention on something that's simple often complicates it. So I wouldn't want to rule, but that's basically what it is. That's what I'm talking about in green crime. The United States has passed laws making it a crime to pollute or damage the environment. Some of these laws include the Clean Water Act, which establishes and maintains standards in the United States for water quality and purity. The Emergency Planning and Community Right to Know Act, which requires companies to disclose information about toxic chemicals they release. Endangered Species Act is designed to protect and recover endangered species, both animal and plant, in the United States. And then the Oil Pollution Act, established after the Exxon Valdez oil spill, which streamlined federal response to oil spills and increases polluters' liability for cleanup costs and damages to natural resources. So a lot of these things sound like they're really good on paper, right? I mean, yeah, we want companies to be held accountable. So how do you think the government holds companies accountable for all these things? Well, they hold them accountable primarily through fines. Right? You do something wrong, we're going to fine you. Every once in a while, they may find that there is severe malfeasance on the behalf of one or a small group of people within that company, and then they may wind up going after them individually and then charging them and, of course, sentencing them to incarceration or whatever, to an actual criminal charge. But for the most part, it goes to the entity the entity itself, and not necessarily the people who are running it or the people who own it, is the one that is going to be fined. So the problem with that, and there is a problem, is that generally speaking, when you get government involved and taking money from one, the dispersion of that tends to get muddied. So you have instances where the government collects this huge fine, and of course it goes into the government coffer, but people who actually suffered the damage, the injury, don't get nothing. Because some of these companies, they might have decent assets, but they don't have a lot, and they get fined so much that they have to close shop. Well, if they declare bankruptcy and close shop, and there's 500 victims that are legitimate victims, and they're like, well, I'm losing my, say for instance, they dumped, kids got sick, whatever, then they have limited recourse. I mean, they're kind of stuck holding the bag, and they have to rely on government to try to be made whole, and that in and of itself is a nasty thing. So sometimes, while it sounds good on paper, honestly, the civil system works. I don't know if have anybody here seen the movie Aaron Brockovich. It was based off a true story. Basically what happened is this young lady went and got a job that she was really not qualified for, working in a law office and acting as an investigator, and she found that there was some malfeasance on behalf of PG&E with regard to their dumping of toxic chemicals and the processing of some of their energy plants in California, specifically in a place called Hinckley, California. And she discovered all this, and she discovered a cover-up, and she started finding that in Hinckley there were a number of different families that were negatively impacted, and in some cases severely, where people had cancer that was attributed to that illegal dumping. So had the federal government come in or the state government come in and sanction PG&E, yeah, they would have been fined. But who knows what would have happened to all the victims? So what happened was this investigator brought it to the attorney who owned the company and said, "Hey, this is what's happening," and went and worked on behalf of all the people in Hinckley who had suffered damages as a result of PG&E's illegal dumping, or rather illegal processing, and then. They at first were going to go to court, but made a decision based off of the length of time for appeals and everything else, and all the court processes, the civil court processes, that an expedited process called arbitration would be in the best interest. And that way, because arbitration was basically, that's it and final, there is no appeal process. And so the court arbitrated and found PG&E liable. And off the top of my head, I want to say it was a $300 million plus award that was given to the victims, and obviously that law firm really grew in size, and the victims of Hinckley were, I mean, obviously there were some people who suffered really, really large losses, but in the same breath, they were legitimately made whole, at least as much of money can make anybody whole, and they had enough to where it would help them deal with whatever the consequences of PG&E's issue, or PG&E not following the law did. So, like I said, the civil courts were able to deal with it, and the legitimate victims of that were the ones who received the reward. And honestly, I think that's one of the areas that we as a nation need to look at with regard to criminal versus civil courts. If civil courts were given a little bit more power and authority for seizing assets, and the processes were quicker for that, I think we would automatically reduce our criminal court load right now for a number of these type of crimes. All right, so moving to number 5, cybercrime for profit. So with the introduction of the internet, and you have to remember when I started back in the 80s, internet was just like in its infancy. 80s and 90s, we had modems that you would plug in, and it would transfer at the fastest, like 56 kilobytes a second. So to put that in perspective, to download one song, you were waiting about 5 to 10 minutes to download a song. So, and that's one song, right? So like now you can do it on your phone, and if you got a good Wi-Fi signal, you can download a song in about 3 seconds. 5 to 10 minutes, and you would have to do it. There was no Wi-Fi signals back then. So money transferring through the internet has become a big thing. And so when that happens, of course, cybercrime is going to increase. So that's the illegal activity that uses a computer for the primary means of the commission of the crime. Common forms of cybercrime include theft, fraud, identity theft, destruction of information, resources, and funds, also known as cyber vandalism. So cyber theft, and you'll need to know these are some of the terms, is the use of a computer network for criminal profit, illegal copyright infringement, identity theft, internet security fraud. Cyber thieves use the internet to distribute illegal goods and services or to defraud people for punishment. Cyber copyright infringement involves software theft where criminals remove electronic copyright protections of the electronic media and then copy them, upload them, and sell that media without license to do so. That happens a lot here in the United States. It's been tamped down quite a bit. When the internet first started becoming popular, right? It was being used for being initially used for commerce and entertainment. There were a number of different companies that operated this way. I'm sure some of you may have heard or remember Napster. That file share program essentially was done for music and allowed music to be shared between the community. Kind of like what we used to do when we were kids. We'd take a cassette tape and we'd get our friend whose mom and dad was nice enough to buy them that cassette tape, and then we'd put them the two in, and then we'd record them, and then now I had a copy of the tape without having to buy. Obviously, that is really difficult to control, and so copyright infringement laws with regard to that were, largely ignored. But when you're talking about millions of bits of information being moved freely and traded between people without any type of monetary exchange, you can see that where the people who perform and made that work of art, that song, may not be getting the full benefit of their work because people are making it, putting it online, and allowing other people to take it freely as opposed to having to go and pay for it. Illegally copied music or copied software is known as wares, and some of the more common wares are movies and music. Overseas, when I was in the military back in 1986 and 87, or 87 actually, late 86 all the way through early 88, all the way through 87, I was in Korea, and that was very common. The video store that you'd go to didn't have trademarked videos, so you would see just a regular video, the DVD cover, and you'd see a burned DVD, and it would have the movie that you were buying or renting. Sometimes it was so bad, like if you got new releases, that they would be in the movie, and you could see somebody actually recording a screen. So yeah, that was a pretty common thing back in Korea way back when. Internet securities fraud is the use of the internet to internationally manipulate security markets for profit. There's three major types. You'll see these again. This is where the big criminal attempt to control the price of the stock by interfering with the natural forces on the market. And so they'll get information, basically privileged information from certain businesses, and they'll utilize that information to their own benefit by either buying more stock at a low rate or selling off their stock before that market or that business or that area crumbles. Fraudulent offering is securities are website designed, and they're designed to sell securities illegally. Illegally touting is when the criminal makes security recommendations to disclose that they're being paid to disseminate favorable opinions. So essentially, they're putting out false narratives to get people to buy that stock or that that part of that business through the different exchanges in New York Stock and NASDAQ and everything else. Identity theft is the using of the internet to steal someone's identity and or impersonate them to conduct illicit transactions, and that's probably one of the most common ones. Phishing is the creation of false emails and websites by criminals to entice victims into providing financial information, and those are becoming more of a problem, and they're becoming more sophisticated. E-tailing fraud is the illegal buying and selling of merchandise, usually involving a substitution of cheap materials for original ones or failure to deliver a promise of purchase or services. And we see that a lot on some of these Let Go and that kind of stuff, those kind of open market, open forum markets, Facebook Marketplace, Craigslist, although Craigslist has almost become defunct now. I actually went on there and not a lot of people use it because of some of these newer, more user-friendly apps that they've got. So, all right, other types of cybercrime. So cyber vandalisms, or cyber vandalism, not isms, is the malicious attacks aimed at disrupting, defacing, or destroying technology. There's really no gain for that. I mean, there can be where a cyber vandal will go in and vandalize a portion of a network and then send a ransom saying, if you don't want the rest of it destroyed, my suggestion to you is you pay me this. Most targets include financial and government computers and networks. Cyber vandals use different types of programs to accomplish the purpose, and you'll need to know these. Viruses and worms, also called malware, replicate within the computer system to destroy software or to hack into a network. So those are specifically designed to destroy software or to bury itself into the network and basically disrupt it. A Trojan horse appears like a benign program. However, when it's open, it spreads that virus. So it's very much like a regular virus, but it's encapsulated. So like, click here, Trojan horse. DOS, denial of service attack, and this is the most common attack, are used to extort money from the internet by threatening to prevent the user from having access to the service. So how do they do that? Most DOS attacks utilize command codes in the root program to tell the computer to do things over and over and over and over and over through many different applications. So it basically opens these apps or opens these commands and makes them do it a lot. And so when you do that, it overwhelms the processing power of the computer, and the computer goes, I can't do this anymore, and that's it. So, but they also leave themselves an out. So if a certain code is installed in that DOS, it stops the program, and in some cases allows the user, the nicer DOS attacks, allows the user to delete the DOS attacked program. So they're not necessarily putting a virus in, they are actually telling the computer to start working really hard, doing a lot of calculations and opening and doing things within the system that will overwhelm the system and not let you, do whatever you need to do in your system. And then cyber stalking is the use of the internet or other electronic communication to stalk or harass, and it's supposed to be stalk, not stalk as in, like stalking, or harass another person. Cyberbullying is the willful and repeated harm done through a medium of electronic text, and this can be done through posting of obscene, insulting, or slanderous messages on social media or directly to the person via emails or text, or to develop a website to promote and disseminate defamatory content. More often than not, that is, I don't want to say limited, but it's primarily what children do, right? A lot of kids will involve themselves in cyberbullying, and they are the result of, and then kids are also the victims of it. And then cyber warfare are politically motivated attacks designed to compromise electronic infrastructure by an enemy nation and disrupt its economy. One of the forms of cyber attack is cyber espionage, hacking, which is targeting the nation's most sensitive computer networks and systems in order to steal important data or to access their defenses. Cyber warfare doesn't necessarily need to go directly against the DoD or any of the government agencies. Sometimes they'll utilize infrastructure targets to institute cyber warfare. And what I mean by that, so what is an infrastructure target? Well, infrastructure target is anything that is necessary for a nation to maintain its current state of readiness. So how would you maintain your current state of readiness? Well, obviously, you need to have the ability to control and land planes, right, throughout the United States. and a lot of that is all computer controlled. You'd have to have readiness would be being able to provide and distribute water through all areas of the country, and that is computer controlled. Power distribution systems, especially nuclear, those are all computer controlled. Transportation, trains, buses, bus schedules. So all of these, while they may not have they're not directly a part of the DoD or directly part of the government, those are major infrastructure components to the nation, and any disruption in them by an enemy nation would disrupt our preparedness, our military preparedness to be able to defend ourselves. And so those are areas that that the government takes very seriously. Okay, number 7, transnational, which is transnational organized crime, and that's a globalization process of creating a global economy through transnational markets and political and legal systems. Whenever a legitimate market is open, the opportunity for criminal enterprise becomes open as well. So transnational organized crime is the use of illegal tactics to gain profit in global markets, typically involving international sale and distribution of illegal commodities. A commodity is a natural and or raw material that is critical to human survival and is traded in domestic and international markets. So what they're talking about here is market-based criminality, but across different countries. So some transnational crime includes types of cybercrime, human trafficking, migrant smuggling, drug smuggling, arms dealing, maritime piracy, trafficking environmental resources, and then counterfeit goods. In the United Nations estimates, not just in the United States, but throughout the globe, that profits of illegal drug trade alone bring in $350 billion in 1 year. You have to remember, this was written in, or this book was published in, I want to say 2015 or 2016. So the information that they have when they conducted that research is probably from 2014 or 2015. And $350 billion a year in just the illegal drug trade. So if you take a look at our stimulus package, which just passed at $1.5 trillion for the entire country, this $350 billion is roughly 30-some% of that. And who knows how much it is now. So it goes to show you how much money the organized crime, especially transnational organized crime, can get, and obviously with money is power. Transnational crime groups include Asian gangs, which typically engage in criminal activity ranging from extortion to arms dealing to human trafficking. Profits are estimated to be right around $100 billion a year. African gangs are highly aggressive and primarily engage in drug trafficking and financial fraud, the Nigerian princess kind of thing. Nigeria is the primary African country involved in the criminal enterprise, and you see that with some of the emails that, well, I haven't received one in quite a while, but that does happen. Russian crime groups encompass the country of Russia as well as other former Soviet Republic and Eastern Bloc countries, and they engage in drug sales, arms trafficking, stolen automobiles, trafficking women, children, and money laundering. So they run the gamut. And then, of course, Mexican drug cartels are large-scale suppliers of narcotics in the United States, and they have kidnapped and killed Americans for profit. They engage in human trafficking, and then, of course, we talked about they engage in people smuggling, and then it doesn't have it in the text, but the sex trade also. The Sinaloa Federation controls approximately 40 to 60% of the country, Mexico's drug trade. All right. And the last slide, controlling global crime. So one of the major roadblocks to controlling and eradicating transnational and global crime is that each nation maintains its own sovereignty. What is that? Well, sovereignty is the autonomy that a nation maintains that cannot be controlled by any other nation. So the United States makes rules, they make their own laws, and as a result of those rules and laws, those rules and laws can't be changed by any other nation, no matter if they agree or disagree. Further, some of these nations' governments see a profit in some of these behaviors so they turn a blind eye. And some of these, the ones that are really guilty are some of the poorer countries. So like Mexico, like the countries in Central and South America, a lot of the cocaine trade and the heroin trade, a lot of the stuff is grown out there, and the governments, they kind of turn their head because they're like, oh yeah, we're trying to help you, but they get money from it as well. Our Congress has passed laws which makes it easier to bring transnational criminals to justice. The Interstate and Foreign Travel Act prohibits travel and interstate commerce with the intent to promote, manage, establish, and facilitate criminal activity. And Congress has also passed the Organized Crime Control Act, Title 9, and you're going to see this again, which includes the Racketeer Influence and Corruption Organization Act. I'm sure you've heard of it, the RICO Act, which enables prosecutors to bring criminal and or civil charges against people engaged in 2 or more of the acts that are prohibited by the 24 existing federal and 8 state statutes. Some of these include murder, kidnapping, gambling, arson, robbery, bribery, extortion, counterfeiting, prostitution, mail fraud, and narcotic violations. What made the RICO Act so famous was Al Capone. So Al Capone got charged with mail fraud under the RICO Act. And so you will likely see the RICO Act and or Organized Crime Control Act, Title 9, later on in your test in this module. So this concludes the lecture. Again, if you have any questions, issues, comments, or concerns, feel free to get a hold of me. It's my hope that this lecture helped all of you, and it was my pleasure to give it to you. And I wish you the best of luck in your upcoming exam, as well as all of your future educational and career endeavors. Thank you very much, and I'm out. Bye-bye now.